Welcome back to This Week in Immigration. I'm Jordan Lapierre. On the program this week, a supersized edition of the Gavel. We round up the latest legal happenings in the world of immigration. But before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you like to get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. It seems you can't talk about immigration in 2019 without talking about the courts. Earlier this week, my colleagues Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy, and Cris Ramón, Senior Immigration Policy Analyst, sat down for an in-depth look at the legal battles shaping the future of immigration policy right now. Here's their conversation.
Hi, this is Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy here at the Bipartisan Policy Center with Cris Ramón. We are without our fearless leader, Jordan Lapierre, who's ill this recording, and we wish him well, and we'll welcome him back next time. But today we're going to dedicate the next to last episode of 2019 to an extended segment of the Gavel, or what used to be called Litigation Corner, on a lot of litigation over the Trump administration's policy and a lot of rulings that have come out in the last couple of weeks. Over the last month, judges have issued a series of rulings that have stopped the implementation of various policies the administration has introduced in a lot of different areas. So, Cris, we're just going to talk through this. Let's start on a lawsuit over the USCIS proposed fee increases. We talked about this a couple of episodes ago. The U.S. Citizenship and Immigration Services proposed a series of changes to their fee structure, including increasing fees on naturalization. One of the aspects of this was eliminating the ability of people to ask for fee waivers for naturalization applications. We just got a ruling on that from a court. Can you tell us what's going on, a little background about that again, and where we stand?
Right. So, we were talking about this, I think, in episode 55 about the proposed fee increases, which is that USCIS is an agency within the Department of Homeland Security that runs largely on the fees of different immigration benefits, such as getting a green card or being naturalized. And they issue adjustments to the cost of these benefits every couple of years. Now, what we saw recently is a proposed fee increase that received a lot of controversy because immigration advocates viewed these increases or these policies as targeting low-income immigrants. In particular, there is this fee waiver, which is allows certain individuals below the poverty line to be able to apply for these benefits and get a waiver without having to pay for them. And so this has really been targeted by the advocates as another, in their own words, as evidence that the Trump administration was targeting low-income immigrants. So this is sort of what provoked this lawsuit.
So the judge ruled a couple of things. One, that that the government did not follow appropriate notice and comment rulemaking process, so Administrative Procedure Act, and that they believed at this point that the plaintiffs might win on that case. Now, interestingly enough, the plaintiffs in this also made an argument that the entire fee ruling was not valid because the then acting director of USCIS, Ken Cuccinelli, was not appropriately named to that role. Now, we've talked about that issue before on this podcast about the musical chairs going on at DHS and the difficulty the Trump administration has had because of so many acting people, and that this might come back to bite them in the backside. And here is a case where it was an actual legal argument in the case. The judge in issuing the injunction didn't get to that argument. We don't know as the case goes forward whether that argument will come back. But I just want to flag that for our listeners because we mentioned it before that the fact that the certain people believe that Ken Cuccinelli never actually was legally entitled to have that position can affect the rules that come out there. So, what happens next? I assume there's an injunction, there's more court cases. I assume the government's going to appeal that case.
I mean, it's guaranteed. That's the strategy. I think that's going to be one common thread in this entire discussion is that the administration will appeal all of these decisions and will continue fighting until it can hit the Supreme Court. But this is going to be moving forward. But I think, it's still a proposed fee increase, and it's getting comments. I think the deadline for the comments is this month, correct?
Well, I think it was going into effect. So I think, one is to regulation, other fees that were going to go up and that have not been enjoined. So those other fee increases, including an asylum fee for the first time, as far as we know, that will go forward. There's a separate case on that one, but this is sort of the first court decision about the fee regulation that's come out. So we'll see where it goes from there. So moving on to another big regulation that was a big issue this year, the public charge rule. So listeners will recall that earlier this year, the government finalized this regulation on who could be deemed a public charge and therefore inadmissible to come to the United States. There were a couple of injunctions, 3 separate injunctions against that rule after it had been finalized. One in California, one in Virginia, and another one in New York. I'm sorry, one in Maryland and one in New York. Just this week, 2 of the appeals courts ruled on the government's appeals of those injunctions and pulled those injunctions back, so allowing the government to proceed, except the New York court injunction is still in place. So for now, it's still enjoined. But this is an interesting litigation for a couple of reasons. The first court to look at it was the Ninth Circuit, the notoriously and presumably liberal court that for the second time this year that I recall, probably more than that, has overturned a lower court's injunction. So this is troubling for a lot of advocacy attorneys who had thought the Ninth Circuit was going to be the place where they could really win. But the judges in this case said that they thought the government had a pretty strong case, that they have the ability to regulate in this area and that there's not been a set definition of public charge, and therefore they can go forward and do that. Although it was interesting, the judge in the California, the chief judge in the California case, although they lifted the injunction, he had some pretty scathing things to say about Congress's inability to act in immigration. Do you remember, Cris, what this is about?
Yeah, I mean, this is kind of a line that we saw as well in the decision of the federal judge that ruled on the lawsuit against the government's lawsuit against the California Sanctuary Cities bill, SB 54, and the line, the tie between both these decisions is essentially the courts are here to be courts, and Congress needs to take up its mantle of actually legislating on immigration issues.
Yeah. And the judge in this case had some choice words for Congress abdicating its role and leaving it to the courts. The second the appeals court case in the Fourth Circuit overturned the Maryland injunction, primarily based on the grounds that the Ninth Circuit had already laid forward. They had a rather shorter order, but they said basically based on the same grounds the Ninth Circuit overturned it. So the New York case is still outstanding. That would be, I believe, the Second Circuit Court of Appeals. So we have to wait and see whether the appeals court in that case would also lift the injunction. Just a reminder to our listeners of the way court cases go. An injunction is an act by the court to stop the actor, in this case the government, from moving forward on what they want to do until the court finishes reviewing all of the legal arguments and whether or not the thing should go through. So it's a preliminary injunction. These have been granted nationwide, stopping the administration from going forward. So even if the injunctions are lifted, that means the public charge rule can go into place. But later the courts could come back and say, you know what, we now agree with the plaintiffs in these cases and it wasn't legally done. Although the bar to get an injunction is you have to show that you're likely to win on the merits. And again, in these cases, the appeals court says they think the government's going to win on the merits.
Yeah, I think that one of the things that's been interesting with this set of cases is that advocates have been winning so much on Administrative Procedures Act's issues. But this is one instance where the government went through the proper channels to issue a regulation, going through notice and comment, when it issued the preliminary rule for notice and comment, and then subsequently incorporating them, issuing the final regulation with comments on the comments that they received from the public.
Yeah, it was a full 2-year process.
Yeah, it was completely, it went through that. So I can't really see I don't want to, start playing fortune teller, but I think that advocates are going to find themselves in a much tougher spot to really continue litigating or seeing their litigation against this rule yield fruit because of these issues.
Yeah, I think it's also interesting that if you remember, the government took its time. USCIS took its time to get this done. Actually, the quote unquote foot dragging on this by the former USCIS director Francis Cisna was one of the reasons that purportedly he was asked to leave because he had taken too long to get this rulemaking out. And Ken Cuccinelli, when he came in, was one of the first things that he pushed through. So ironically, the care and time that the government took to get this rule out might actually be the thing that allows it to go forward at the end of the day to see what's going on. So we have some other court cases that are going on. Let's move down to the border. So there have been 2 new programs, asylum programs, that have been put in place by Customs and Border Protection to deal with migrants at the border. We've talked a lot about migrant protection protocols, or MPP, and Remain in Mexico. We've talked about the asylum bans, the one that said, the regulation that said that people who apply between ports of entry would be ineligible for asylum, and then the one that said that people coming through third countries would be ineligible for asylum. That first one was enjoined. The second one was enjoined for a while, and then that injunction was lifted. So that's now in place. But now they're doing 2 additional programs which would fast track that process of credible fear and then expedited removal to a period of days for people coming in at the border. And the initials or acronyms for these programs one is PACER and HARP. And PACER is for non-Mexicans, and HARP is for Mexican asylum seekers. And the program would have the initial credible fear interview, I think, within 24 hours of arrival, and an expedited case review of the asylum case within about a week. And the advocates are saying that this is just too short a time, that most of these people are kept in CBP custody or ICE custody and don't have time to properly put together a case to claim asylum, that there's a lack of due process. And so, Cris, what happened in these lawsuits? They filed the suits. Do we have any ruling on these, or these are just now been filed?
I think these are new.
Okay.
That there's the allegations that specifically that there is a limitation in due process, and that these processes don't allow the immigrants to be able to even access, be able to work with an attorney on these cases. So it really revolves around the notion that these fast track processes limit, in their own words, due process through the asylum process and through the removal process. And that's been one of their primary concerns that we've seen with the way that the administration has been managing border arrivals has been, is due process being protected? Of course, Theresa, we've talked a lot about this as to whether that's actually a real concept in immigration removal proceedings.
Right. So due process and immigration proceedings, being administrative proceedings, are essentially what the government says they are under the law and in its regulations. There are some constitutional protections that apply, but we've also seen the Supreme Court has ruled many, many times that when we're talking about people at the border, the rights of the individual are subsumed to the rights of the government to inspect and adjudicate who gets to come in the country. So, I think, CBP is using these programs in part in conjunction with the fact that the asylum ban that says if you came through a third country, if you came through Mexico but you're not from Mexico and applying at the border, you're ineligible for asylum, using that as a ground to be able to expedite these cases, because most of them would not be eligible if they came through Mexico. Now, the Mexican process is different. The Mexicans would be placed in expedited removal, but still there's other, by fast tracking the process, they would have a hard time. And the Mexicans, of course, can't be sent back to Mexico under MPP. So go ahead.
Yeah, no, absolutely. I mean, that's the key thing. Is 2 points to make there. Is one is that this is targeting Mexican asylum seekers, which is interesting because if we're looking at reporting about the numbers of individuals coming to the border, some of the reporting we've been hearing is that there's been an increase in the number of Mexican arrivals of individuals seeking asylum and arriving at the border. I think they're now superseding the number of Central American migrants arriving, and it's interesting to see this program pop up in response to that. The other important thing is these pilot programs are taking place in El Paso, which has really sort of served as a laboratory for a lot of these border policies. And I think we haven't really talked about that the way that
we should.
Yeah.
Yeah. So going back to, I think it's early 2018, El Paso appears to be the first place that the zero tolerance child separation policy was piloted before it was announced nationwide that summer. The new port courts and it was the second place that MPP was implemented, and the port courts, the temporary soft-sided facilities where they're doing the MPP court cases by remote, is going on in El Paso. El Paso wasn't the largest, the place where the most people were coming in. That was usually South Texas, but I'm not sure why El Paso has been where they've decided to pilot this. It may be that they just have better facilities there to do that, and amenable, Border Patrol and Port of Entry staff. But it does seem that El Paso is a place where CBP is trying out a lot of new things.
Yeah, I think when the history of sort of this crisis is really written, I think that there could be an entire chapter dedicated to what's happening with El Paso, and there's been a lot of really good reporting about this specific issue. So I think it's always interesting as our listeners think about this, is really where are these programs coming from, and all signs always seem to point to El Paso.
All right, so staying on the border, now we're going to get to one of our favorite topics on this podcast, the wall. So there's a couple of different cases that we need to talk about, and a couple of different wall projects. So let's start not with President Trump and the government's effort to build a wall, but another private sector group called We Build the Wall, that is trying to build a private sector wall on the U.S.-Mexico border. So for listeners who have not followed this, a group of individuals led by a immigration activist named Brian Kolfage, after the government shut down in early 2019, when Congress did not fund the wall, and before the president had declared a national emergency, started a private fundraising campaign called We Build the Wall to raise private sector donations and money with the intent of giving that money to the president to build the wall if Congress would not. And they raised some $25 million. It was not an insignificant amount, but they ran into some problems because they found out that legally you can't give the government money for a specific project like that. You can donate to the Treasury generally, and you can donate to reduce the debt, but you cannot, it's not legally permissible to give the government money for a specific project like that. So instead, this group decided to incorporate and build on its own with that money wall along privately owned lands along the U.S.-Mexico border. And I think the first piece they built was maybe in New Mexico, and they've been working on a parcel of land next to the National Butterfly Center in South Texas. And they have run into some issues. So the Butterfly Center, which also filed suit against the federal wall, but did not succeed in that suit. That's how it was tossed out by the court because they said they didn't have standing to sue. But they sued these private sector people, We Build the Wall, for building the wall next to the Butterfly Center and saying it would impede the environment there. And they did get a temporary restraining order from a Texas judge, a local Texas judge, Texas state judge, until a hearing on December 17th, saying that there's enough information that these people building this section of the wall had not followed appropriate permitting and licensing requirements and other things. In a separate suit filed by an organization called the International Boundary and Water Commission, which is a binational organization of the U.S. and Mexico who is charged with enforcing the International Boundary and Water Treaty between the United States and Mexico, which is an over 150-year-old treaty that regulates the Rio Grande River and water between the United States and Mexico. So this organization is responsible for ensuring that all construction along the river ensures that in the event of rainfall or significant flooding, that always sufficient water from the tributaries is divided between the United States and Mexico. So they have the right and legal authority to approve or deny any construction along the river. And they claim that in spite of repeated requests, the We Build the Wall people has not given them sufficient information to adjudicate whether or not the construction they're doing is going to impede the water flow. And they also got a temporary restraining order, this time from a federal judge. What's really interesting about the IBWC case is that, unlike the butterfly folks, the IBWC is a U.S. federal governmental entity who is represented by the Department of Justice. So in this case, you have the Department of Justice who sued to stop this private sector entity from building a wall. In the other cases, DOJ is defending the federal government against those trying to stop the federal wall lawsuit. Is this complicated for enough anyway?
Yeah. I mean, this is obviously interesting because we're seeing a new front opening on border wall battles on this issue, and it is interesting to sort of see private citizens and a private organization trying to do this. Obviously, this is on private land, so to do that, they can't do this on federal land. But it really sort of shows two things to me. One is that there is a very small but very vocal and dedicated portion of the American public that really believes in this and wants to see this being constructed, and will give their money for it. But I think the more interesting question really is revolving around this issue of seeing this new legal front opening up, because we've just seen so much of it being private organizations suing the federal government. Now we're seeing sort of a private organization like the Butterfly folks against We Build the Wall, and in a way that kind of mirrors what we've seen with litigation in other areas where it's been federal government against state government against counties and cities. It's sort of, so in other words, we're seeing
everybody's getting in the game.
Exactly, in the litigation game.
Yeah, everybody's getting in the litigation game. The other thing I find interesting about the IBWC case, and it's worth understanding that, as a private sector entity building any portion of the wall, it's not, they don't have the ability to exercise the same authorities the federal government does. So the federal government, DHS, has authority given to it by Congress to waive, for example, environmental impact assessments to build the wall, to waive other obligations. They can't necessarily waive the treaty obligations, but they work pretty closely with IBWC. But they don't have to follow state or local permitting processes, for example. But a private sector entity building on private land does, and there have been other lawsuits against this organization that didn't follow even local permitting when they were building other parts of the wall. So, they're moving ahead, evidently in spite of the temporary restraining orders. So we'll see. But there's a couple of hearings coming up in the next week or so. So we'll see what happens on that. But it is very interesting. The intention is that after they complete their 3.5 miles or whatever on this private property, that they want to be able to turn it over to the federal government. And just like they couldn't give the money to the federal government, there's a lot of questions about whether or not there's a legal authority or way for this organization to actually turn over that. I mean, it's built on private property. Does that mean the private property owner is going to give their land to the federal government? What's interesting about that is here's somebody looking to give private property to the federal government. In other places where the federal government wants to build the wall, they have to file for eminent domain to condemn the property, to take the property for fair market value from the owners. And there are other places along the border where those owners are fighting that. So again, the saga of the wall continues. And just yesterday, there was a federal court case against the federal part of the wall. So, Cris, do you want to talk about this one?
Yeah. So there's been a President Trump at the beginning of this year, after shutting down the government over not receiving funding for his border wall, issued a national declaration of emergency about the situation at the U.S.-Mexico border, about migration, in order to appropriate funding for federal funding that Congress had appropriated to other agencies for the purpose of building the wall. This generated a series of lawsuits. And this one, I believe, also came from
This was down in Texas. So there was a previous case in California.
But this was filed by, I believe, was it the city of El Paso or the county?
Yeah, I think it was local officials down there filed this case.
And they filed claiming that the construction of the wall would do harm to them and harm to the city. And in this particular instance, a federal judge down in Texas actually ruled in favor of the plaintiffs and declared, I believe, the national emergency to, at least not necessarily declaring it was illegal, but that the government could not use funds that had been appropriated for the Department of Defense for the purpose of building the wall.
Yeah. So the specific thing, this is a preliminary injunction. It is a nationwide injunction, and it specifically prevents the government from using $3.6 billion in military construction funding, which the government had proposed to reallocate toward building the wall. And this was a very big political issue for a while, because when you're talking about military construction, military construction projects are in a lot of congressional districts around the country. And it includes things like building schools on military bases and housing and things that have, frankly, infrastructure projects that have been backlogged for DOD for a little while due to sequester and other things. So this was a really big deal, and Congress would not have done this. I think military construction funds are usually fairly closely held by Congress. They're going to ensure that money gets there. But under the national emergency, this was a big pot of money that DHS was going to get from DOD to do this. So this prevents the government from doing this, at least for the moment. Now, of course, we know this is also going to be appealed into the Fifth Circuit in Texas, I believe. So we'll see where that goes. You know, we mentioned the previous suit. The state of California and some other California actors had filed a similar case in California. There was an injunction by a California judge that was actually overturned by the Supreme Court back in July. But that was for a different pot of DOD funding. And they said that the players in that didn't have standing to sue. So at least in this course, the Texas judge found, at least initially, that the plaintiffs did have standing and that this was an illegal workaround of Congress. And the ruling was pretty clear that, you know, Congress had specifically said, we are not going to give you this funding, and specifically said you cannot have any more than this funding for any other things. So, you know, we'll see where this goes, but this could be a big setback to the president's plan to try to build 450 miles of border wall before the election in 2020.
Right. I mean, this is going to be one of those things where, like you said, that this is going to be potentially could derail those plans. The question is, if that's the case, you know, what other ways will the president try to find funding to be able to address this issue, and then will litigation in response to those actions continue to stop this? And I think that's really the key question moving forward. And of course, we're talking about this at the end of the year as appropriations are coming up.
Yes, a reminder that the government shutdown deadline is now December 21st, unless they reach a deal to keep the government open or extend it. And the president has not yet said what he's going to do. He's going to ask for wall money again. The border wall is still an issue. The DHS spending bill has not been approved. So, you know, if he's now been prevented from moving this pot of money, he's going to have to go back to Congress, I guess, and figure out if he can get anything there. We'll see. Right. Well, 2019 has been a very litigious year on the immigration front. We will continue in 2020 to bring you periodic episodes of the Gavel, where we will try to follow as best we can the latest and greatest in immigration litigation. But we'll be back in another couple of weeks where we will do a look back and look ahead, 2019, the year in review, and a little look ahead at 2020. So we hope you will join us again then.
That's our show for this week. We'll be back after the holidays, but in the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_Bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. I'm Jordan Lapierre. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself, and produced by Cris Ramón, Yafat Tawahata, and me. Our editor is Yafat Tawahata. and the executive producer of BPC Podcasts is Ashley Swearingen. That's all for now. Join us again next time on This Week in Immigration.